Grand K Strategies presents Who Qualifies as the Exception to FATCA Requirements. The Foreign Account Tax Compliance Act is an extraterritorial jurisdictional imposition created by the U.S. Congress upon sovereign nations by the United States government. It is addressed under Chapter 4 of the Internal Revenue Code by statutory laws that are applied to a rather limited jurisdiction. This Grand K Strategies video is a short introduction to one particular component of FATCA that has escaped the attention of the vast majority of foreign financial institutions and their legal staff, the exception to FATCA statutes. One first learns of this exception by reading the IRS publication Instructions for Form 8938 under the heading Who Must File the Form 8938. Here, you'll find in the tip comment inserted under Who Must File the direct reference to the exception to all FATCA requirements. The exception is stated to be if no income tax return is required. This is a very unusual concept for many to comprehend, that there are those who are lawful non-taxpayers. However, when you read the federal appellate court case Economy, Plumbing, and Heating versus the United States, you'll find in part, revenue laws relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. The targeted audience and jurisdiction being addressed by lawful non-taxpayers are Americans in the constitutional republic and having citizenship there by birth or naturalization. Grand K Strategies provides full documentation on the exception to FATCA, and thus the elimination of all FATCA statutes and regulations towards select Americans for any legal obligation to file and pay a federal income tax for the rest of their lives. As a result, Grand K Strategies is capable of correcting any misapplication of FATCA with foreign financial institutions for clients who meet the exception to FATCA requirements. The foreign financial institution will have no issue with any FATCA obligation imposed via any existing treaty between its home government and that of the U.S. government. One who's a lawful non-taxpayer is synonymous with the term non-U.S. person. Part of the Grand K Strategies documentation also addresses the limited jurisdiction for the FATCA laws as well as the laws for the federal income tax. The jurisdictional exception has been accepted by the U.S. Tax Court in thousands of cases presented to this court on IRS claims of enforcement actions such as assessment, lien, and levy for our select qualified American clients who use our service and documentation. Grand K Strategies provides full documentation on our clients' behalf to the FFI to document our claims by existing federal tax laws and federal court decisions that eliminate all concerns related to FATCA restrictions placed upon any international bank. We identify all presumptions that haven't previously been recognized by the bank. Everything that Grand K Strategies presents in our documentation to an FFI distinguishes the limited jurisdiction to which the federal income tax and FATCA requirements are only targeted toward. Any potential client must first be intensively screened to become qualified for this process so that the bank can be assured that there is no inappropriateness in documentation provided to them on the part of a qualified American client. Recently, we have secured admissions by a legal process with a federal agency and the IRS that FATCA statutes and regulations do not apply toward non-U.S. persons who cannot be identified as specified individuals as stated in the instructions for Form 8938 as any of the following categories. 1. A U.S. citizen. 2. A U.S. resident alien. 3. A non-resident alien individual who makes an election to be treated as a U.S. resident alien for filing a federal income tax return. And 4. A non-resident alien individual who elects to live in American Samoa or Puerto Rico. This is just a sample of terms that have to be properly defined within the context of the Internal Revenue Code so that the foreign financial institution will understand that any Grand K Strategies American client will never and cannot be legally defined to be such. Clarifications in our documentation for the bank will be made on terms such as U.S. person, United States, states of the United States, U.S. citizen, and non-resident alien individual, and all FFIs will be more than satisfied of the correct legal and lawful foundation within our documentation. Furthermore, Grand Case Strategies will document for the complete satisfaction of any FFI that our screened American clients derive no income from sources within or without the United States, as stated in the Internal Revenue Code. This will include validation that the Internal Revenue Service admits that there are no requirements by its statutes pertaining to personal services by non-resident alien individuals. Foreign financial institutions with a need to fully understand the FATCA exceptions and the limited scope of FATCA should contact us for a meeting to understand the multifaceted dimensions that are now available with our documentation. After all, time is money, and neither should be wasted. If you're an affluent American interested in privacy and wealth management and a desire to incorporate into your lexicon the significance of what the FATCA exception can provide you, please contact us to begin a discussion on the positive impact that our efforts can afford you once you qualify to become a client. Simply send us your contact information, email, and phone, along with your name and any foreign financial institutions you've dealt with in the past. We're booking appointments 2 weeks out due to our workload and want to schedule timely and productive meetings for interested foreign financial institutions and Americans who need our FATCA-related services. Thanks for viewing our video.